different way. And when we come in here and people who have no political axe to grind whatsoever put forward the motion in the way it has been put forward, there should have been another methodology rather than putting the roadblock of an amendment which is basically saying to everybody else, on the one hand we ask you to sing from the same hymn sheet, but not this evening.
Thank you, Senator O'Murco. I now call Senator Jillian van Turnhout. You have 6 minutes.
Thank you very much, and welcome, Minister, to the House. Firstly, I would like to very much support the statements that were made this evening by my independent colleagues, Senator McNeill and Senator Spone. And, Minister, I believe that their interventions have spoken with great sincerity to our call to ensure the independence of the social welfare appeal system. I also would like to welcome the report by FLAC, which I think provides the evidence and underpins this motion. And I would also like to stress that in bringing this motion forward this evening, that my colleagues, and in particular Senator Spone, undertook considerable consultation and consideration of all of the issues before we put the motion forward. So I'd like to thank her for all of that work, and so therefore for me it's very easy for me to endorse, because I know that it's very evidence-based what we're trying to put forward here this evening. I'm going to limit my contribution to stressing the importance of ensuring that the appeal system should be underpinned by and comply with due process and human rights principles enshrined in the Irish Constitution and Ireland's regional and international human treaties obligations. The requirements of independence are well established. The tribunal should be independent, in particular from the executive. This principle was laid down by the Supreme Court more than 60 years ago in McLaughlin and Minister for Social Welfare, when it found that the appeals officers and deciding officers under the Social Welfare Act are required to be free and unrestricted by ministerial control in discharging their functions under the Act. Currently, all of the appeals officers, including the Chief Appeals Officer, are nominated by the Minister for Social Protection, despite having its own premises and staff. It therefore cannot achieve perceived and actual independence or transparency, both of which I believe are essential for public confidence in the system. Currently, there is no public appointment process for appeals officers and no publicly available terms of reference. Appeals officers are serving civil servants transferred from another part of the Department of Social Protection to the Appeals Office, which raises concern over the possibilities of external pressures, including the removal at any time back to another part of the Department of Social Protection. The selection criteria for appointment in the Appeals Office should be made public. In addition, appeals officers should be employed from a variety of backgrounds to allow for diversity and range of expertise. Regular training should be provided to all appointed appeals officers and should include welfare law, immigration law, EU law, human rights law, as well as cultural awareness and sensitivity in relation to ethnic minorities, sexual orientation and transgender issues, as well as with people with disabilities. Minister, my colleague Senator Spone outlined on the importance of fair procedures, and I would just like to support what she said. I'm not going to repeat what she has said in the House, but I would like to add that a control audit of the Department of Social Protection's decisions should be carried out to identify any trends or patterns of poor quality decisions. And the last point I'd like to come to is the right to an effective remedy. The right to an effective remedy is well documented in the jurisprudence of the European Court of Human Rights in cases such as Kudla in Poland and Konka in Belgium, both decided in 2002, and in General Comment number 19 of the UN Committee on the Economic, Social and Cultural Rights in 2008. And in the context of social welfare appeals, I believe that there must be an effective remedy provided in our national framework. The current appeals process complies with Article 13 of the European Convention on Human Rights and the right to effective remedy. However, the delays in the process itself, as well as in the court system, may counteract the value of an appeals as an effective remedy. The remedy may not be effective if the case is not heard or decided upon within a reasonable period of time. In such cases, appellants may have to rely on charity, handouts, emergency payments, or help of friends and family to sustain themselves over a lengthy period of time to avoid hardship. Minister, in conclusion, we all know that the Department of Social Protection accounts for 40% of overall government expenditure. We know that nearly half the country's population benefit from social welfare payments. And clearly the social welfare system affects a very substantial section of the population, inevitably including the poorest and the most vulnerable. We know the increases in social welfare applications, but the decisions at the heart of the appeals concerning people's entitlements to various types of benefits represent life-changing decisions for tens of thousands of people. The decisions often literally determine what, if anything, is put on the table for dinner, what goes into children's lunchbox, and whether coats are being worn to bed for warmth. Senator McCarthy has said and argued that we should get it right first time. And yes, I agree. But equally, we need to ensure that we have an independent and transparent system of social welfare appeals. And we do not believe that the system in place is independent and transparent. Appellants are entitled to a fair, transparent, accountable and independent appeal system. And I believe it's the duty of the state to ensure its delivery, economic difficulties notwithstanding. Thank you.
Thank you, Senator Van Turnhout. I now call Senator Barrett. We have 4 speakers offering, and we have about 15 minutes, so if we could confine it maybe to 4 minutes or thereabouts.
Okay.
Give everybody a chance,
yes,
if that's okay.
Please remind me if that's required, Laska Herlick. Thank you, and welcome to Minister Perry.